Chapter 10. Conclusion. A. Types of injustice. Injustice comes in many forms, most of which do not arise within the domain of law. But some injustices are legal injustices. When expressed in legal form, these injustices must be corrected by legal means, that is, the means recognized within the common law tradition. Those means classically involve political, electoral, legislative, and judicial processes. In democratic systems of government, questions of who gets what, when, and how, and of the relative fairness of these social and economic allocations and relations are often best left to the former processes. However, when an alleged injustice involves constitutional organization, institutional obligations, fundamental rights, and certain other normative constraints on government power, the common law tradition has allocated the responsibility of correcting this sort of injustice to the courts. In these instances, the political processes of government themselves must be regulated by the rule of law, enforced by judges in accordance with common law constitutionalism. Many citizens and officials, including judges, assume that the authority of the judiciary to correct certain legal injustices is necessarily subordinate to the democratic processes of government. Judges, so the story goes, are charged with interpreting the law and perhaps with articulating the law, but not with challenging or changing the law made by representative and politically accountable branches of government. Judges must apply the law as it is. This was the assumption of certain judges during the period of legalized slavery in the United States. This is the assumption of many American judges and theorists today. And due to the doctrine of parliamentary sovereignty, this is the assumption of many judges and theorists in England. But it is important to be careful in determining what type of injustice is at issue, because when an injustice is expressed in a legal source, it is the judge's institutional responsibility to attempt to correct that type of injustice. It is just as much a mistake to assume that judges are powerless to correct injustices inside the legal domain as it is to assume that judges can correct injustices outside that domain. Within the legal domain, the common law tradition empowers and obligates judges not only to enforce the law as it is, but also to correct injustice and develop the law. There are limitations here as well, however. Not all moral outrage at a perceived legal injustice can honestly be traced to and expressed in a source recognized as law by the common law tradition. For common law judges to correct injustice through the judicial process, the moral evaluation and proffered correction of injustice must at every stage be amenable to expression in a judicial ruling supported by a reasoned opinion. B. An alternative. Common law judges do more than simply apply the law. Common law judges also develop the law. These are, I have argued, their two fundamental obligations. These two obligations can be legally grounded in two ways, textually or conceptually. I have presented source-based and conceptual arguments for the judicial obligation to apply the law, and I have presented source-based and conceptual arguments for the judicial obligation to develop the law. The source-based arguments for the judicial obligation to apply the law center on stare decisis and legislative supremacy. Stare decisis, through its use in judicial practice, requires judges to apply case law. Legislative supremacy, through its recognition in judicial practice, requires judges to apply statutory law. At times, the constraining force of these doctrines seems to demand that judges reach unjust results in certain cases. This has led some theorists to reconstruct the doctrines in the hope of allowing judges to avoid their occasionally untoward effects. It seems to me, though, that we demonstrate more respect for the authentic importance of these doctrines in the common law tradition if, in response to the injustice they sometimes appear to require, we attempt to locate an equally fundamental countervailing obligation that legally justices judicial refusal to enforce unjust laws, rather than promoting reformulations of stare decisis and legislative supremacy that would merely enervate their genuine impact on judicial decision-making. The conceptual argument for the judicial obligation to apply the law acknowledges that an irreducible part of the common law judicial function is the application of settled law in the resolution of legal disputes according to accepted practices of legal argumentation and decision-making. Put differently, for a common law system to be a common law system, Its judges must frequently, as part of their institutional role, apply the law as they find it to the situations brought before the court for resolution. The judicial obligation to apply the law is, however, only part of the story. I have also argued that common law judges have a legal obligation to develop the law, sometimes by refusing to enforce unjust laws. This obligation derives from common law principles articulated in case law, and from the nature of the common law system, method, and tradition. The common law cannot be divorced from its commitments to constitutionalism and the rule of law. In other words, in a common law system, fundamental principles exist that constrain abuses of power by other branches of government. One of these principles, which I discussed at length in Chapter 9, is the principle of legality. Another principle, which I mentioned in Chapter 8, is the right of access to the courts. Injustice, whether legislatively directed, executively attempted, or judicially indicated, is always subject to the subsequent review and evaluation of the common law judiciary. As I have described this process here, that evaluative review and its consequences differ in different jurisdictions. But those differences do not alter the existence and importance of the judicial power and process at issue. Common law review, as I have called this judicial authority and responsibility, can be traced either to legal sources or to legal concepts. I have here examined sources, i.e., case law and judicial practices from England and the United States. Bonham and Omachund demonstrate that the evaluative judicial role and corrective judicial process have long and deep roots in Anglo-American legal history and doctrine. And such cases as Annisminic and Sims show that the burgeoning of parliamentary sovereignty has not swept from the English legal landscape either these fundamental aspects of the common law judiciary or the importance of fundamental common law principles of justice. Whatever terms they happen to use, many English judges remain steadfast in their efforts to protect fundamental rights and institutional values against the legislatures and the executives overstepping via ouster clauses or administrative discretion of their rightful exercise of political power. In the United States, Calder, Kishholm, McIlvaine, and Fletcher, together with Ham, Bowman, Lindsay, and Jones, established that judicial review was not, and need not be conceived only in terms of a constitutional document. Before and after constitutional review was introduced into American law, common law principles were used as an independent, alternative basis for judicial review of legislative action. Moreover, as with Annisminic and Sims in the English context, Rochin, Webster, and Morrow among others demonstrate that judges in the United States will ensure the legality of government action and will defend their institutional integrity and authority against challenges of various sorts, regardless of whether those challenges originate in executive action, legislative provision, or judicial decision. Legal sources are not the only means, however, by which a common law judicial obligation to develop the law can be defended. I have argued that the nature of the common law itself, as a legal system and a legal tradition, grounds a legal obligation for common law judges to refuse to enforce unjust laws. Through its design to develop over time toward substantive justice, the judge's integral role in that process, and the consequences of judicial failures to fulfill that role, the obligation to develop the law is understood to be intrinsic to the common law judicial function. Simply put, for a legal system to be a common law system, its judges must possess the institutional authority to develop the law. Substantively and structurally, common law review reveals an inherent institutional relationship in all common law legal orders. The developmental refinement of existing law and the evaluative review of governmental action cannot be decoupled in the common law tradition. The common law judiciary's institutional independence has long been recognized as an intrinsically valuable feature of the legal system and the larger constitutional architecture in which it fits. Indeed, this is one of the fundamental values of the rule of law and the subjection of governmental power to legal limitation. This is, in other words, the connection between common law review and common law constitutionalism. To those who view judicial review of any stripe as worrisome, common law review will doubtless seem an ill-advised expansion of what already is tantamount to judicial hegemony. For the most part, though, these worries are overblown. Historically, theoretically, and doctrinally, common law review is a long-standing, workable, and circumscribed aspect of the common law judiciary's authority. But it is nevertheless an aspect of that authority. Those who find it objectionable must explain the basis of those objections and appreciate the ramifications of them, because those of us who prize this part of the common law's heritage will need very persuasive reasons to relinquish it. C. Unsatisfying answers. My arguments in favor of common law review, and more generally, in support of the common law judicial obligation to develop the law, are motivated by the desire to explain more fully and accurately the real scope of the common law judiciary's authority and responsibility. In particular, I hope to expand the three truncated alternatives suggested by those who have considered a judge's options when asked to enforce an unjust law. It may be that in some places at certain times, under particular circumstances, all a judge can do when faced with an unjust law is resign, misrepresent himself, or enforce the law as it is. But this is not all a judge can do in England, the United States, or any contemporary common law system. Judges have another legal option and another legal obligation. Common law judges who find themselves in this situation have a legal obligation to develop the law by refusing to enforce an unjust law. This is their obligation to the legal system, the judicial institution, the public, and the litigants who appear before them. It is their contribution to the proper articulation of public values and to the integrity of the judicial process. D. The moral formal dilemma. The three unsatisfying options of resignation, misrepresentation, and enforcement derive from and depend on the moral formal dilemma, with its myopic vision of the judiciary. Once we see that the legal side of the dilemma is not limited to a stunted, mechanistic image of the common law judiciary, we begin to appreciate the true nature of the dilemma posed by unjust laws. Unjust laws do not present judges with a moral formal dilemma at all. They present a legal dilemma, a conflict between the judge's fundamental obligations to apply the law and to develop the law, given the exigency of the situation, and provided that the judge is satisfied after careful reflection and consideration that the epistemic threshold has been reached. The judge's obligation to develop the law outweighs the, in this case, conflicting obligation to apply the law. E. Unjust laws. As long as people need laws to govern themselves, and as long as these laws are made by people, some of these laws will be unjust. As long as the threat of unjust laws persists, people will and should consider how judges ought best to address that threat and its occasional actualization. To this point, consideration of these problems has left judges with only three possibilities. But mendacity, abnegation, or acquiescence are not the only options. The common law tradition and legal principles permit and require more of judges. Judges must develop the law. That, too, is a fundamental aspect of their legal obligations. Sometimes, as in cases involving unjust laws, development demands that judges subject government action to the rule of law. This should not elicit fear or frustration. The common law has always functioned this way, and common law judges have always, in one form or another, fulfilled this function. The common law tradition recognized long ago what we sometimes still lose sight of today. Only when the waters are pure can we hope to see down to the riverbed.